Okay, Diane hasn't looked at her note. They did stamp it. Uh, but anyway, you got to understand, these people just gave you a boatload of money. Write them a thank you letter. Yes.
I did that with Hyperion Capital, who was the ones that sorry, yeah, we're live. I did that with Hyperion Capital Group, and I sent it certified mail. This was months ago. They never responded. But I didn't do all this. I just wrote them a general thank you letter. So maybe I should do this and send it through a process server.
Yes, I would write them a nice thank you letter, acknowledging them, putting in the UCCs, which are in the booklet, that acknowledge that they did discharge you from the obligation. Just something short and sweet, and thank them for that. And then I would prefer that, if it was my case, I would have a process server serve them that.
I think maybe they did send me a letter back saying that they transferred my loan.
Yeah, you're not talking in the mic, or it's off.
I'm sorry. I think they sent a letter back maybe saying that they transferred my loan, and then I needed to take it up with Wells Fargo.
Okay, that would be non-responsive. You either deny something or you don't. Yeah, non-responsive is just like they didn't say anything about it. You have to deny something directly. It's got to be responsive to what was stated.
So would you just add that to your complaint?
Well, if I sent them the letter and it was process served, then I'm already in court. They just don't know it.
Okay.
Yeah.
Hi, John. Okay, here again. When I got actually I did request for my promissory note to be sent out to me, and the trustee, one of the vice president of the trustee, California Rican, responded to me that they have my original note. So I requested a copy of
Okay.
front and back
Okay. Wait a second. That they have your original loan or your original note?
note.
Okay, you said loan. Okay, go ahead.
And then I requested it via fax and via certified mail overnight to me. So they sent me a single page copy of what it is, and I saw that it was stamped. So I requested to meet with them to show me the original face to face. And I went to their office in Rosedale with two witnesses with me, one a notary and one person with my husband. And what
Okay.
they have shown me is different from what they have sent me.
Okay. And why does that not matter?
Well, it does matter.
No, it doesn't matter. We went through this yesterday. You sold him the note. What does it matter?
Oh, okay.
Guys, I don't want to keep having the same discussion. Does it matter what they did with the note?
No, okay.
Only this, they stamped it.
Yeah, once they sold it, I don't want to see the note. I've been to so many law firms to look at so many notes and blah, blah, blah. I don't. Show me the note was a trick. Okay, I'll just say it flat out. You guys are friggin' duped. And you guys are duped well. Okay? You were duped by all the other gurus. I hate to say the word other gurus because I'm not a guru. I don't want to be in that class of individuals. Agreed. That it doesn't even make sense. The foreclosure is not incumbent on the redemption of a promissory note. Who does not understand that concept completely?
No, I brought it up only because you said send a thank you note. I did send.
No, I said send a thank you letter.
Letter.
A note and a letter are two different
Okay,
things.
I did send a thank you letter for sending me.
Put your mic closer.
I did send them a thank you letter for sending me the copy. But now.
Okay, but you're misunderstanding the point. And I don't want to spend all morning going over this. If you, just this one point, and then we'll get off of this. If you received a copy of the promissory note, and I don't say your promissory note, because you sold it, it ain't your friggin' note. We got that, right? if you receive a copy of the promissory note, in law we'd say the promissory note in question, and it has a stamp on it, whether it be on the note itself or on the allonge, that says pay to the order of, what do we know in law that they converted that note to?
Check.
And what did they do with that check?
Cashed. Deposited.
Cashed it and deposited the funds from selling that check into an account. Why?
Six weeks may lend it.
7 times.
What else was stamped on that promissory note? It might have been signed in blank, endorsed, or it might have not been endorsed. I don't care. So, what happened to the obligation of the obligor?
It's released.
Why? And that law is where? If somebody gives you $500,000, should you ignore them or should you thank them? Thank them. I guarantee you, you give me $500,000, I will thank you. I will send you something. Probably more than that. If you're an old guy, a good hooker, I don't know. You give me $500,000, I'm sending you something.
I think where some of the confusion came up is we use the legal term obligor of obligation. I don't think people realize that they are the obligor.
Okay, when you, I'm, thank you, because I perhaps am remiss in making a statement on that. Whoever signs the promissory note is the obligor. Absolutely, yes, that's who the obligor is. Okay, let's go ahead. We're going to start court. Marty, you're going to be judge. Marty's been judge a couple times. Cindy, you're going to be defendant. Did Bill step out of the room?
Hello.
Oh, okay. Cindy, you want to come up here?
We have a new, am I on this thing? We have a new transcript on the Mortgage Challenge site. This is an announcement, by the way.
Okay. Give that to Cindy. Bill, you're going to sit with, oh, wait a minute.
I wasn't finished.
No, Bill, you're going to sit here. Cindy's going to be plaintiff, or defendant first. You
I think I'm in contempt already.
probably,
If you're not on the Mortgage Challenge site,
well, and you didn't go out drinking last night.
I wasn't finished.
That
You're
was
interrupting
contemptuous,
me.
wasn't it?
Please stop
I know.
interrupting me.
Same type pants.
Get on the
Uh-oh.
Mortgage
You
Challenge
in?
site if you
Okay.
haven't been on there. We
Oh.
do have a new
I don't know.
transcript on that covers some of the material presented this weekend.
I don't have a big ear.
I don't hear myself talking on the microphone.
Thank you.
Well, you're talking so low.
John, I'm the defendant attorney?
Besides that, you
Yes,
need to read
you're
it.
the
Okay.
defense attorney.
Okay.
Just
You said
till
defendant.
we get a feeling of this,
Okay.
and then we'll start up. So we're gonna skip all the preliminary aspects, go straight into it. We'll do opening statements. You guys are the jury. You're just gonna listen for now. You guys are just the gallery. You're just here visiting. What's the rule for the gallery? Shut the hell up. Shut up just isn't. So, oh, wait. Cigarettes out of my pocket. Okay. So, we'll make the opening statement. You don't really say anything yet. No. Okay. Go ahead.
You're the plaintiff?
Yeah. So, Stewart v. Chase.
Okay, Mr. Stewart, can you proceed with your opening statement?
I don't think they.
Hello, hello.
Okay, for the record, guys, hang on a second. The microphones are on for purposes of the recording more than anything. So if you can't hear it through the speakers, just try to listen the best you can so we can get it on tape. If not, it's going to feedback because there's so many microphones
Okay, are all parties present?
Yes, John Stewart, plaintiff.
Cynthia Cantrell for Bank of America.
Okay, you get 2 microphones. You may want to move one away.
Okay, sorry.
Okay, Mr. Stewart, do you have an opening statement?
Yes, Your Honor. We're here today. As you can see in the pleadings, the banks have committed numerous acts of fraud to unlawfully foreclose on my property. I've presented to the court the certified copies of the documents they recorded in the county recorder's office in violations of ARS 39161, 13-2301, 13-2302, all the way through 2310, 13-301 through 13-306, numerous counts of each, numerous violations of each, several federal statutes, and pursuant to 18 U.S.C. Section 4, I'm hereby informing the court of the defendants' numerous criminal acts and acts of terrorism and their declaration of war on the United States. And
Objection, Your Honor. I can't not speak here. This calls for speculation. There's no foundation. He calls for a legal conclusion. Facts aren't in evidence. He's making conclusive statements here.
Your Honor, no, I am filing criminal charges in front of the court for their acts of terrorism. I can do that pursuant to the USA Patriot Act, and short of the defendant's rebuttal and evidence therein, they must be arrested immediately.
Overruled. I'm going to allow him to continue with his opening statement.
Okay.
That notwithstanding, Your Honor, they do not have standing to foreclose in this issue. I will be having a expert witness under penalty of perjury testify that the defendants in this matter have no standing to foreclose. Hence, the documents they filed in the county recorder's office to commence the non-judicial foreclosure proceeding were the criminal acts. So, after the opening statement, I will bring up my expert testimony or my expert witness to the stand to present his opinion pursuant to the documents already admitted into evidence to show the defendant shouldn't even be here. They have no standing to be here. They had no standing to commence the unlawful foreclosure. So they should actually already be arrested. They really shouldn't be there. They should be in the jail across the hall.
Mr. Stewart, I'm going to put that to the weight of my decision. Do you have any more?
No, that'll be all.
Thank you, Your Honor. We're here today because this homeowner has signed a deed of trust and a promissory note obligating him to pay Bank of America $450,000, and he's trying to get out of his obligation and basically get a house
Objection,
for free.
Your Honor. Pursuant to UCC 3-302, 3-406, 414, and numerous others, the defendants knowingly, intelligently, and willfully, with full knowledge of the consequences thereof, discharge the obligation of the obligor by altering and or modifying the said promissory note. They have forsaken permanently and in perpetuity their right to use that promissory note against me because they've already sold it.
Your Honor, I have to object. He got to state his whole opening statement, and he interrupted me.
Mr. Stewart,
I'd like to strike everything he said.
overrule you for the moment. And
Excuse
let her
me, Your
continue.
Honor, she did object to my opening statement.
But then you asked me to wait till his opening
I would
statement was
prefer
finished.
that, you let her continue, and it'll go to the weight.
Your Honor, I have all these documents here that the defendant has signed, or the plaintiff has signed, agreeing to this loan and agreeing that he is obligated to pay this money for this house, and he is just trying
Objection,
here to
Your
steal-
Honor.
I'm
Hearsay
trying to
calls
make
for
my opening
speculation.
statement, Your Honor. He got to make his.
Objection, Your
Mr.
Honor. It's
Stewart,
hearsay.
Can we let her finish her opening statement?
Probably not. Objection, Your Honor. It's hearsay. She's making conclusions on documents she was not a part of signing or involved in negotiations therein. She cannot make an opening statement based on hearsay.